So in June Medical versus G, the question before the court is whether a Louisiana law, which requires that any abortion provider in Louisiana have admitting privileges within 30 miles of the abortion clinic where they provide services to women, so will be upheld as a valid regulation. Admitting privileges are when you provide a tremendous amount of documentation to a hospital that shows that you have the right to admit patients there and to see them there. Texas and Whole Women's Health had a very similar regulation at issue. The text of the Texas statute, which is struck in Whole Women's Health, and the text of the Louisiana one, and they look like cut and paste with some tiny textual changes. Now, Louisiana has a little wrinkle that was a little bit different than the specific regulation in question in Texas. In Texas, to be admitted as a member of the medical staff of a hospital, you actually had to show the hospital that you were going to be a good referral base. In Louisiana, to get admitting privileges, there were actually several ways to do that. One is like the Texas way, show us that you're going to send us a bunch of patients. In other words, show us a business case for you being on our medical staff. A second was to look backwards and actually show your competence to the committee that evaluated the right to admit patients or to get admitting privileges. Show your competence by showing your past patient history in a hospital. Well, here you've got catch-22, because if you're only an abortion provider and you don't have a separate private practice, you never will have enough hospital patient records from the last 12 months to show them that you're in fact competent. So how would Whole Women's Health affect the outcome of this case? Whole Women's Health said you have to actually do a balancing test of benefit to burden. So what's the undue burden test? It is essentially whether a substantial obstacle is put in the path of women to accessing a pre-viability abortion. And just to make that concrete, in this particular case, we have wildly competing claims about whether the admitting privileges rule is going to erect an undue burden or substantial obstacle in the path of women. So one account from the district court is that they will have gone from 3 abortion clinics and 6 abortion providers to 1 abortion doctor, 1 abortion clinic for 10,000 women. So you look at that and you go, oh my God, that sounds like a substantial obstacle. If you take the Fifth Circuit's very fact-intensive review of the district court's record, if these physicians had actually used good faith efforts to obtain those admitting privileges, at most, we would have 1 doctor who ends up having to leave one of the clinics, and that work could be divided in such a way between the remaining doctors that at most the women at that clinic would experience a 50-minute delay. That doesn't sound like a substantial obstacle in the path of anyone. So you have these dueling claims. You have from the abortion provider side that the circuit gets it wrong, that this is just flouting Whole Women's Health. The counterclaim says Fifth Circuit got it right. And then they have questions that they also want the Supreme Court to take up on cert. And so with this newly recomposed court, I think many people are holding their breath on both sides. If you're pro-life, finally you have this validation of the value of life, and if you are pro-choice, it's potentially a cause of great fear for many people.